Welcome back. Time is 7:42. It's a tool you probably use a dozen times a day, and now it's under fire from the U.S. government. A 3-week-long hearing into Google began Monday as antitrust officials look to put a stop to what they call a search engine monopoly.
The U.S. Department of Justice wants a federal judge to ban Google from making certain deals with companies like Apple. Those are deals that lawyers say can shield users from Google's competition and possibly spread valuable information.
Joining us this morning to talk about what a monopoly is and if these challenges to Google are legal, we've got Queen City News Chief Legal Analyst Khalif Rhodes. Good morning, Khalif.
Morning.
Nice to have you here.
Yeah.
Okay, when you look at Google, its dominance in the search engine world, do you see what they've done, this antitrust lawsuit? Has that been a monopoly, or is that just the way the pieces have fallen when it comes to competition?
To your first question of what is a monopoly, right? That's what you talked about in the intro. It's just like the board game. If you're attempting to get all the pieces on the board, all of the cards, so that you can control the corner, so no one else will be able to get past that corner without paying you, well, that's in essence on an elementary style level what a monopoly is. And so obviously in U.S. law, that is, in most other major countries, that is against the law when you're attempting to monopolize some brand, some area, and not allowing competition to be in that space. It goes against which our free market is supposed to be about. And so, yes, have the chips fell that way? They have. But did Google do something to intentionally make those chips fall that way? Well, that's what the court's already said. And we got to go back a couple steps. This is the second time that Google was found to be running a monopoly. In the last couple of days in their ad space, a monopoly was found. The court said, yes, you guys have been running and operating in a monopoly in your ad space when you advertise. The things you see pop up all over the place, that Google has 100% controlled that space where advertisers have to go through them, that users have to go through them, that there's no other space for competition. Well, this case that we're talking about here is from last year. Last year, court already said they are operating and running a monopoly when it comes to search space, that Google controls it, creates it, dominates it, and these agreements that they have with specifically with Apple, they make sure that no one else can even enter. Apple gets paid millions of dollars a year from Google to ensure that they direct folks to go to Google for their search. So that is the problem. It's not that they have maintained it, which is also problematic, but it was created through a monopoly, through these small deals that no one else can even break through.
Well, so talk about what precedent we have here with other big companies. AT&T and Standard Oil come to mind with this.
Yeah, I mean, those are older ones when we were really just trying to wrap our hands around what monopolies look like. It was kind of too late. I always say that we're reactive with our laws and with our rules, and you recognize that something has happened. It's like, hey, we got to roll this back. They've gotten too big. Amazon, those companies, the last administration, the Biden administration was going off after big tech, specifically big tech, and attempting to try to figure out how we can roll some of these things back. If we're looking at precedent, Apple, they were most recently sued. Microsoft most recently sued, and Google most recently sued all through the last administration. I think even with this one right here, had they not got a ruling in the last administration, I think the Trump administration probably would have stopped going forward with this type of push, the type of roll back some of this monopolization. But the remedies are different. Back then it was break it up and just get rid of it. The remedies for today are not the same. So one of the things that the government is asking is for that they divest from Chrome. Well, that sounds good. Make sure that Google removes Chrome, sell Chrome off. Well, does that really answer the question? So, because if the search space is the problem, and now Chrome will just be owned by someone else, so won't they have a monopoly now? So now we have to try to find innovative ways to figure out how we get rid of this thing. And most of the time, it's allowing and inviting other folks in to compete in that space. And so you have to try to get rid of these partnership agreements that they've created, and at least try to figure out how you get other people involved in those partnership agreements. Because if you can't, then that monopoly will never be broken. It'll just be monopolized by someone else. They just won't be named Google. It may be someone else in the future.
And to your point, some of the things they're considering is banning exclusivity deals for search engine placement, mandating Google license its search data to other competitors. But the other thing here going to is the AI thing that they're saying, okay, Google, you can't also be putting your AI into things, but they're saying, whoa, this wasn't supposed to be about AI. This is about the search engine.
Well, I mean, it's a logical next step. And even though I just mentioned a couple times that we are reactive with our rules, with our precedent, with the things that we attempt to create, this is one I think that's forward-looking, that's unique in this situation where the government is saying that, okay, we recognize that this is a problem, that they have monopolized this search engine, and one of the ways they have done it is through these deals. And we also can see, if we're looking down the road, that they're creating this monopoly with this AI, that if we allow them them to purchase companies, AI companies in the future, that they will not only monopolize the AI space, but they'll use AI to monopolize the search engine space. So they are talking about that as well within this hearing of trying to find ways to ensure that they don't do that. I don't think they'll be able to ban Google from, participating in the AI space. One of the remedies that I've heard them that recommend, and I think this is a good idea, is to ensure that they have to get approval before they can acquire an AI company. When you're trying to grow, when you're trying to get bigger as a company, as you said, the chips fall where they may. I'm grabbing every company that is a competitor that may, be targeting me to try to protect myself, to insulate myself, but also to acquire technology so that I can grow. So some of that stuff is legal, some of it isn't. What they're doing with this AI space is they're saying, before you can go purchase the small guy, you're going to have to get it approved by us so we can make sure that you're not trying to create a new monopoly. I think that's something that the court has entertained and will entertain likely in their outcome.
Google is such a part of our speech. It's
Yep.
now a verb. So even
Yep.
if something were to happen, if it were to downsize, sell off, I think people are always just going to say, Google it. Even if you're looking at Bing or
Yep.
something else. So it's just, it's a part of our
remember
culture.
Ask Jeeves, remember that?
Oh, I
Remember that?
loved him.
I don't know, maybe Jesus will
loved
be
that.
resurrected. We'll have to see. It is the week of Easter.
It sure is.
Or it was anyway. All right.